Hi, everybody. This is Samantha from the law offices of Samantha Wolfe, and we're located at 20 East 6th Street in Suite 206 in Waynesboro, Pennsylvania. And you can reach us at 717-655-2676. And thank you so much for jumping on our video for our monthly virtual seminar. Every month, we like to pick a topic and explore all the different legal concepts in a way that allows clients and referral sources to get information that they might not otherwise receive. So this month, we're going to go ahead and talk about some charitable giving. As part of our mission statement, we feel like one of the things that we should be doing as a law firm is educating those clients that we do have, any prospective clients that we have, and referral sources. So I just wanted to take this opportunity to let you know that that's one of the reasons that we do this virtual seminar. You can always check us out on our YouTube channel. We do the seminars and then we'll do other videos there to talk about different legal concepts. So today I'm excited. We're talking about charitable planning. Can you spare some change? And when we have our weekly marketing meetings, we're always trying to brainstorm ideas for our monthly virtual seminars. And when it comes towards the end of the year, that this is the time that usually our clients or taxpayers are looking at making charitable donations as the year's kind of settled out, figuring out what you want to do. So we thought it was an ideal time to talk about the different charitable planning techniques that you can use. And like we've been doing in our latest series of virtual seminars that we started in September, what we're going to do is we're going to base it loosely on some client examples that we've run across here at our office and talk to you using hypotheticals about the type of charitable planning that those clients used. So it's not just going to be information. We're going to give some examples and show you how those legal techniques fit into real life situations. So I always want to start off with some basic information. So what is charitable planning? Charitable planning is a way to support charities and nonprofits that might have a special meaning to you, or sometimes we have clients who feel like they want to include charitable planning as part of their estate plan. Sometimes it's a certain percentage of their estate. Sometimes it's for a particular charity and their mission. So it can be expressed a number of ways. It can be included as a beneficiary in the estate plan. You can give lifetime gifts, and you can also include bequests in wills or trusts to charities. There are some tax benefits to charitable planning. So just like every seminar, I can't help but talk about some of the tax implications of the type of planning. So when you want to donate to a charity, what you want to do is figure out, can I, when I donate, take this as a deduction for my income tax purposes? So we want to make sure that we're always maximizing any deductions on the income tax side of things. And also, for charitable planning, there's some estate tax deductions that you can get as well for federal estate and federal gift tax planning. Most people aren't thinking of it in that context lately because the federal exemption is so high, but we're going to talk about ways that you can get some deductions when you pass away, or the way you can make certain assets not subject to Pennsylvania inheritance tax because it's going to a charity. So we're going to talk about gifts during life. We're going to talk about donations that you might make when you pass away, and then we're going to talk about the tax implications of that. So our first example is the Matthews family. And Jess, let's go ahead and advance to the slide where we have the assets. So we have Rachel Matthews. She has no children of her own, but she does have two nephews that she wants to have as the beneficiaries of her estate plan. And then her assets consist of the following items. So we have an IRA account that has about $800,000 in it. We have a primary residence that's worth about $250,000, and we have a brokerage account that has about $350,000 in. Now, the reason why the asset composition is so important is because when we're talking about planning, we really need to know what are the assets, how much is in each type, and then for tax planning purposes, it helps to know whether we're talking about qualified funds or non-qualified funds. So that's why in this example, I have noted about the IRA and then the brokerage account, so that way we know the IRA is obviously qualified funds and the brokerage account is non-qualified. And when I met with Rachel, she had some concerns or some things that she wanted her plan to address. So the first is, so often nowadays when I meet with clients, they have done their own research, which I always appreciate. They'll come in and they'll say, I want to talk about this specific topic, this specific planning technique. And part of what we do here is we try to educate them about other planning techniques that they might not know about, but also give them more details about certain things they may have come in specifically asking for. So in this case, Rachel had come in, she'd done some research, and her financial advisor had talked about IRAs and had talked about how she might want to convert some of her traditional IRA to a Roth IRA so that when she starts drawing down from the Roth IRA, she doesn't have to pay income tax on those distributions. If it's a traditional IRA, when she reaches age 72, she's going to be required to take distributions, and those distributions would be subject to her income tax. So she wanted to talk about Roth conversions, or converting a traditional to a Roth. She also wanted to talk to me about charitable remainder trusts. So she specifically mentioned remainder trust, but we are going to talk about other charitable trusts as well, charitable lead trust. And then there's always the difference between a unit trust and an annuity trust. And we'll talk about those two in the subsequent slides. But she came in, she had those two specific questions about conversion and then about the charitable trusts. One of the things she wanted to try to do was reduce her income tax or have some income tax deductions as part of her planning. So more and more, we're seeing clients who want to shift from minimizing federal estate tax because the exemption is so high. They may instead want to try to maximize income tax deductions and minimize their over income tax liabilities. That was one of her goals. The second goal that she came in wanting is that if she did use a trust, she had done enough research to know that a charity would be named as the beneficiary of a charitable remainder trust. And she wanted the ability to set aside this money and pick charities or substitute charities at a later date, depending on what missions, what mood she felt in as far as what she wanted her estate to benefit. So let's go ahead and advance. I want to talk about some trust. So that we talked about all of these things in Rachel's appointment. So the first is that we wanted to talk to her about what a charitable remainder trust is. So know that there are two main charitable trusts. There's a charitable lead trust and there's a charitable remainder trust. Most people that I meet with come in wanting to talk about a charitable remainder trust. And the reason for that is a charitable remainder trust means that the charity receives whatever assets are owned in that trust when the donor, or in this case, Rachel, when she passes away. So that being said, Rachel's not losing a lot of accessibility to her assets. She's kind of earmarking these funds to a charity, but the charity does not get those funds until her death. So that's what a charitable remainder trust. The second category is a charitable lead trust. A lead trust is different. A lead trust is where the charity gets a certain amount in the trust initially, and then when that term is over, for example, it could be like a 10-year period that the charity is getting a certain amount from the trust. When that 10 years is over, then it would go to named individual beneficiaries. So a couple of things to know about charitable leads and charitable remainder trust, and these are generalizations. You need to make sure that you're actually working through the scenarios in your own situation, and know that we do have a special program that we can run the numbers during your appointment. But the generalizations that you need to know about a remainder trust versus a lead trust, usually a lead trust, you're going to get a higher income tax deduction because a lead trust has the initial amount going to charity. And so usually the income tax deduction is going to be higher with a lead trust. Now, that's not always true. It depends what you're funding it with, how long the term is, what the payout is. But generally, a lead trust is going to get more of an income tax deduction. A remainder trust still gets a deduction, but really where the remainder trust gets the maximum tax benefit is that when the remainder amount in the trust is going to charity, none of that is subject to inheritance tax or income tax. So you're really getting a deduction on the back end when you pass away. So you still do get an income tax deduction, but you're going to see the most deduction coming when you pass away. So those are the two generalizations I wanted to make sure we knew about the two types of trust. So a remainder trust, like we talked about, just generates a stream of income for the trust settlor or for any other beneficiary. So in Rachel's case, if she did a remainder trust, she could be the individual that's getting the income stream, or she could have it be any other named individual. Now, know that the income tax deduction that you get with a remainder trust depends on the age of the person who's receiving the payouts during life. So obviously, you're going to get a larger income tax deduction if it's an older individual, because there's a shorter period of time that it's paying out to an individual, which means a larger amount goes to charity. Okay. And what this does is it really provides the settlor, in this case Rachel, a life estate where she still receives a certain amount off those donated assets, a stream of income, and then when she passes away, it's going to go to the charity. So that's a charitable remainder trust. The tax incentives of a charitable remainder trust, and usually in the legal community, we do a lot of acronyms. So for charitable remainder trust, we're going to call this a CRT, or you might hear words like a CRUT or a CRAT. Those are other words to describe it. And a charitable remainder trust allows the trust settlor to take a federal income tax deduction whenever the trust is funded. Also, the investment income that is earned is tax exempt, and it helps keep more of the trust assets inside the trust for the charity. Charitable remainder trust can offer some benefits. So the first is it does help you plan major donations to charities that you support, and you're doing this donation all at once and you're kind of putting it into the trust, and that's what's triggering the donation. Number two, you're providing a predictable income stream for the life of the settlor or for a specific period of time. And number three, it allows you to defer income taxes on the sale of assets transferred to the trust. So I worked with one client where they had low basis real estate and they transferred it into this charitable trust. The property was sold down the line, and rather than the taxpayer or the donor having to pay all that capital gains, instead it's inside the charitable trust, and so you're able to defer that income tax. And then lastly, may allow you a partial charitable deduction based on the value of the charitable interest in the trust, which is what we had talked about. So let's talk about a charitable lead. So a charitable remainder means that the charity gets it when someone passes away on the back end. A lead trust means that they get it at the outset. The charity gets a certain amount. So you can use a charitable lead trust, which is a type of irrevocable trust, to make a series of payments. So it could be like an annuity payment, which is the same amount every year, or you can use a unitrust amount, which is based on what the value of the assets in the trust are on a yearly basis. And that can then benefit that charitable organization. So I always like pictures. So Amy made sure to include a picture in here talking about a charitable lead trust. So we have the donor on the left. If we follow the golden arrow that would transfer the funds into the lead trust, then a certain amount goes to the charity, and then the beneficiary receives the amount once the period of time is over. So if we say that we're going to do a charitable lead trust and the charity is going to receive 5% annually for a 10-year period, once that 10-year period is over, then it's going to go to the beneficiary that's listed in the lead trust. A lead trust, it can be the settlor, so Rachel, she could be the beneficiary, but more often than not, it's usually the non-settlor. So in this case, it could be her nephews would be the beneficiaries who are receiving the trust assets after the charitable period. So again, if it's a 10-year period, once that 10 years has ended, the remaining amount could pay out to the nephews. That's typically how a charitable lead trust works. So in this case, we have visuals. I love the visuals. So we have Rachel's visual here. So what I did is, in this case, I ran the numbers. I did it if it was a remainder trust. I did it if it was a lead trust. I picked a whole bunch of different terms. So in the file, when we were meeting with her, we did like a 10-year, 15, 20, 25-year term. And we just worked with the numbers to figure out what felt most comfortable for her, because we wanted to make sure with a remainder trust that annually the amount that she was receiving, which is 5% of the fair market value of the trust assets, we needed to make sure that that annual amount felt comfortable for her. So if she wanted more income, then we would have changed the terms of the trust. In this case, what we did is we set up the charitable remainder trust. Rachel was the trustee. The successor trustee was one of her nephews. During Rachel's life, she was the beneficiary for a 5-year period that began when the assets were transferred into the trust and when the trust received those assets. The unit trust amount, like we talked about, was 5% of the fair market value of the trust as it was valued on the first day of the taxable year. And then what happened is upon termination of the unit trust period, that 5-year period, the trustee was going to distribute the principal and income out to a charity. And the benefit here is, remember, one of her goals is she didn't necessarily know what charity she wanted. So in the trust, we gave the trustee the ability to substitute charities as long as it qualified. So we had, that had to be a public charity, a 501c3. But again, the trustee could substitute charities in there so that way, if she changed her mind, it's still being set aside for charity. It has to be 501c3. She still gets the deduction. But if she changed her mind, she's not locked in there. And what this offered Rachel is when she funded it. So if we go back to her assets, Jess, can you just go back to her assets once? What we did is we took $150,000 from her brokerage account, which had $350,000 in it. We took $150,000 out of that and we contributed that to the trust. Then we took a portion of her IRA, which is a traditional IRA, and we converted some of that to a Roth IRA. So go ahead and advance just to the visual. When we converted it, what we were able to do is we were able to get her a deduction, an income tax deduction. Go back one, Jess. We were able to get her an income tax deduction of $116,220.45. So in the year in which we funded this trust, she's able to get that deduction and convert from her traditional IRA to a Roth because she has that corresponding deduction. And again, we wanted to do this so that it was in the same tax year so that we generated the deduction in the same year that we're converting, so she has no increased tax liability. Because remember, if she converted the traditional into a Roth or a portion of that, she'd have to recognize that in her income. So in this case, she's able to convert it. She didn't have to claim it in her income because she has a corresponding offset of the $116,000. What this does is then she has a Roth that has this amount in there. And when she receives withdrawals from that Roth, she's not going to pay tax on it. Now, know that Rachel can do this type of trust in future years as well. So if she wants to trigger a deduction and convert more from her traditional into a Roth, all we have to do is work with the charitable remainder trust options and get her a deduction that will allow her to convert more. Now, she has quite a bit in her traditional IRA, so she may not want to convert it all. She may want to convert, a large chunk of it. And this is all based on what her goal was. So she really wanted to try to lower her taxes as she aged. And so for her, this was a great planning technique. So Jess, let's go back just to make sure. I want to talk about her goals just to explain how this met her goals. So one of the goals that she had was to create the income tax deduction. So she was able to do that. That corresponds with her goal to convert to a Roth IRA. Now, I will tell you that the idea to convert the Roth IRA or convert the traditional to the Roth really came from her financial advisor. So we really worked as a team because the financial advisor looked at what her IRA funds were and said, you know what, there's really going to be a problem when she starts taking RMDs. We may want to provide more of a diverse retirement portfolio so that she's not always taking money and getting hit with income taxes. And then the other goal she had was the ability to pick charities at a later time, and the charitable remainder trust allowed her to do that. So this is an example of one way. Now, I will tell you that if we had different options of charitable planning, know that this is really kind of the sophisticated high-end type of planning, and we want to make sure that it actually fits in with the client's goals. So that's why we have a program that allows us to run the numbers. And I remember sitting in the financial advisor's office that day, and we just kept saying, well, what about this number and this term, and let's see what that does. And then we just talked to Rachel and we said, how does this number feel for you? So it was more of working as a team to figure out what met her goals and still left her in a comfortable position. So this is an example of how we use a charitable trust. Our next example, case number 2, is the Jones family. So we have Jack and Robin Jones. They're married with 3 daughters, Stacy, Sally, and Wendy. Jack was born in 1941 and Robin was born in 1943. Now, normally I don't disclose years of birth, and know that, again, these are fictional people. But I did this because you're going to see in a minute why it's really important. So we needed to know what their date of birth year was, because this allows us to calculate what their RMD distributions will be. And you're going to see why this is important in a second. So that's why I have the years listed here. And then what I've done here is they have other assets, but I've captured what their IRA assets are and then their brokerage account. And again, it'll make some sense as to why I didn't include their other assets in a second. But know that Robin's total retirement amount, because she has an IRA account, hers is the top one of $137,000, but then she does have a $1.4 million IRA account. So her total retirement is 1.5 million. Jack's total retirement account, he has one. It's a traditional IRA of 450,000. So when we run the numbers, Robin's total RMD for 2022, based on her date of birth, and you plug in the numbers and you kind of put what the fair market value is. So we know her total RMD for 2022, the amount she'd have to take would be $72,843.60. We know that Jack's total RMD for 2022 is $23,195.88. So that means between the two of them, their total retirement RMD for both husband and wife, Jack and Robin, is $96,039.48. The IRS is going to make them take that amount in RMDs. So we're not looking at any Social Security amount. We're not looking at any interest or dividends that they've accumulated. They have a high income solely just with their RMDs. We're not looking at any of the other income at this point, but just know that if they already have $96,000 in income, when you count all of those other things, Social Security, interest, dividends, anything like that, that's going to push them up even higher. So one of their goals when they came in and talked to me was that they really had a charity, Hershey Medical Center, that they wanted to donate a certain amount. And again, one of the benefits was that, of course, they wanted to look at what the tax implications were. Okay, so let's advance to the next slide, because there are 2 options that we talked about. And know that when we talked about these 2 options, they can use one or the other, or they can use both. Okay, so the first option is what we call a qualified charitable distribution, or sometimes it's referred to as a QCD. Okay. And I get asked a lot about this at the end of the year. And the reason why is because IRA owners age 72 and above, or if you were taking RMDs prior to the Trump law change for the Secure Act, it's 70 and a half. Again, they have to take RMDs. When they take the RMD, they have to include that RMD in their income tax for as part of their adjusted gross income. So we sometimes have clients who say, you know what, I am going to have a lot of income this year. What are my options? So a qualified charitable distribution is a real easy thing. It doesn't require us to draft anything legal. It's something that we just like to educate our clients. Very easy to do. A lot of our clients do this. So let me explain the concept. So IRA owners age 70 and a half or over have the option to transfer $100,000 or $200,000 if you're a married couple to a charity tax-free each year. So what that means is the IRA owners who are 72 or older, or who are 70 and a half and older and have been taking their RMDs, can use the qualified charitable distributions for their RMDs that year. So the RMD transfer to charity is not included in their adjusted gross income. So what that means, using this example for Jack and Robin, remember they had a total RMD distribution between all of their IRAs for both of them of $96,039.48. So they're going to receive that in RMDs in 2022. So they could take that entire amount, because know the max is $100,000 for an individual or $200,000 for a married couple. So they're below that in RMDs. They could take that entire $96,000 and they could have it go to a charity of their choice. And that amount would not have to be included in their adjusted gross income. Now, again, they're not getting an actual deduction. This is not a deduction that you're getting. It's just that you don't have to include that RMD in your adjusted gross income. Now, most people aren't going to wipe out their entire R&D. Most of the time, people are just going to take a portion of it. So think about it this way. When you're running the numbers, and this is why it's important to have your accountant and your attorney working together, you want to run the numbers and figure out what tax rate do I want to be at? What amount do I have to give to a charity to get there? Because most people, like I said, aren't giving the full 100,000, or as a married couple, 200,000, but they're going to give a portion of it, okay? Qualified charitable distribution means the distributions are tax-free as long as the distribution is paid directly from the IRA to the eligible charitable organization. The transfer can be done electronically or by check payable to the charity. But know that the check or electronic transfer cannot be made to the IRA owner first. So it's not something where you receive the distribution and then decide to do it. It has to be directly from your IRA trustee or administrator directly to that charity. Okay, you can't have it come to you first and then try to do this planning technique. What you'll get is you'll get a form 1099-R from the IRA trustee that shows what amount was an RMD and what amount was a qualified charitable distribution. If it's a qualified charitable distribution, then that amount is entered in line 4A on your income tax return. And that's shown on box 1 of your 1099-R. So whatever is in box 1 of 1099-R, you take over and put on line 4 of your income tax return. If the entire distribution, so if Jack and Robin in this case take the entire $96,000 and have that go to charity, the entire distribution is a qualified charitable distribution, then you enter 0 on line 4B. If they still receive partial RMD distribution and only a portion of it goes to charity, then the amount that's considered an RMD is entered on line 4B of your tax return. Qualified charitable distributions are not deductible as a charitable contribution on Schedule A, like we talked about. This never comes into your adjusted gross income, so it automatically goes to the charity. You must get written acknowledgement of the contribution from charity before filing the return. So typically this must be a written thing that states the date, the amount of the contribution, and indicate whether or not you as the donor received anything of value in return. Okay, so that's charitable option number 1. So in this case, Jack and Robin could just take that entire $96,000 or a portion of that and have it go to Hershey Medical Center. Another option that they would have, option number 2, is to do a charitable donation. And know that they could also use what we did in Rachel's case in example number 1. They can always use charitable trust as an option, but in this case, the option number 2 that they ended up going with was a charitable donation. So charitable donations, I have to give a little history here just to kind of clarify. So charitable donations were expanded in 2021 as part of COVID recovery. So taxpayers in 2021 could deduct $300 in charitable contributions, or a total of $600 if you're a joint filer, without itemizing deductions. This is important because normally you cannot take a charitable deduction unless you are able to itemize deductions. So remember, as a taxpayer, you have the option of a standard deduction or taking itemized deductions. You're only going to get the charitable deduction if you itemize for income tax purposes. So if you use the standard deduction, you're not going to be able to take the charitable donation as a deduction. So in 2021, there was no limit for charitable contributions. I'm sorry, this is calendar year 2020, so you'd be filing in 2021. There was no limit for charitable contributions for calendar year 2020 that taxpayers could deduct up to 100% of their adjusted gross income. So know that the last 2 years have been a little bit different because of COVID. So in 2020, you could deduct 100% of what you gave to charity. In 2021, they allowed standard deduction taxpayers to deduct $300 or $600 if you were married, and you still got that even if you took the standard deduction. In 2022, As of right now, so we're December 8th, and the reason why this is important to know is that sometimes they wait and the IRS will change their mind about certain things. So no, as of right now, I'm telling you the information as we know it now, it's returning back to normal in 2022. So if a taxpayer uses a standard deduction, then they cannot take a charitable deduction for any contributions. As of now, there's no $300 of charitable deduction if you are a standard deduction taxpayer. Charitable contributions for taxpayers who itemize deductions also have limits depending on your adjusted gross income. So we're not using 2020 rules where you could deduct up to 100% of your adjusted gross income. In 2022, we're back to limits, which we're going to get to in the next slide. But first, I always like to put information at the bottom that might be helpful. So we have the standard deduction for 2022, single taxpayer and married individuals who are filing separately, their standard deduction is $12,950. Married individuals filing jointly have a standard deduction of $25,900. So you're only going to be able to itemize if you don't take that standard deduction. So these are the limits for charitable contributions. So cash contributions to a public charity, because there are two types of charities. There's a public charity and a private foundation. So these I pulled right from the IRS website. Cash contributions to a public charity, you can deduct up to 50% of your adjusted gross income. That's what the AGI stands for. Contributions of short-term capital gains. So the first bullet point is cash contributions. The second would be if you're contributing short-term capital gain property to a public charity, it's 50% of your adjusted gross income. Cash and short-term gain contributions to a private foundation, you are limited to 30% of your adjusted gross income. So it's a lesser amount. So that's why when we're doing setups for charities, that's why it's always so important to figure out if they're a public charity or a private foundation, because it really affects what deductions donors can get when they contribute to that charity. So let's go to the next one, contributions of long-term capital gain property to a public charity. So this is long-term capital gain is 30% of your adjusted gross income. So it not only depends on whether you're a public or private charity, it also depends on whether the contribution is cash or whether it's a capital gain. Contributions of long-term capital gain property to a private foundation is 20%. So the lowest percent is going to be if it's a long-term capital gain and it's made to a private foundation. Now, this is as of right now. We'll see what happens as the year comes to a close. So what donations qualify for a charitable deduction? Only contributions that benefit a charitable purpose. So this was interesting. In my research, I realized that Rolex is owned by a nonprofit. So you can't deduct buying a Rolex, even though Rolex is owned by a nonprofit. So those of you who are thinking of giving everybody you know a Rolex and then taking it as a charitable deduction, you're not going to be able to do that. That would have been a great Christmas idea. So you can't do that. Other thing to know is organizations must qualify for tax exempt status before being granted the tax benefits. So organizations operated for a religious purpose, charities, scientific, literary, or educational purposes, those are going to be organizations that qualify for tax exempt status. Nonprofit veterans groups, fraternal lodges, cemeteries, burial companies, they may qualify for the exemption, but only if donations go towards eligible purposes. So that being said, if you're making a donation for something that's not part of their nonprofit, then you can't take a deduction. The other thing to know is quid pro quo contributions. So best example I can give you is sometimes we see in our area, we have the country club and they sometimes will sponsor charitable events, and you'll be able to play a game of golf, which would normally be $200. You might be able to play it for $100, and the difference is considered a charitable contribution. So know that if there's an exchange of money for something, like you're paying lesser because there's going to be a certain charitable donation made, you can only deduct the amount over the fair market value for what you received. So in this example, if the game is normally $200, you're paying $100, you can only deduct the $100 that's going to the charity. You can't deduct, the full $200, okay? Donated items, you can deduct the fair market value of what is donated. You need to request a receipt from the charity, and you need to know for a non-cash contributions, typically you include them on Form 82, 83. For cash contributions, it's going to go on Schedule A, which is where you do your itemized deductions. So in the case before we move to the next one, so in this case where we had, let's go back to the example just so that we can talk through this. So in this example, what we decided to do is Jack and Robin did make a qualified charitable distribution of a certain portion of their RMD, which they actually had done in years prior. That's not something new that they did this year. But what they did decide to do is they decided to make a qualified charitable contribution or donation to Hershey Medical Center. And they are going to figure out if they're going to make a cash contribution or a non-cash contribution. And then they're able to take the deduction up to the percentage of the adjusted gross income. So if they make a cash contribution to a public charity, they can deduct up to 50% of their adjusted gross income if they itemize. Okay, so I wanted to make sure to go over those two topics. Know that, again, nothing legally has to be drafted from our perspective. This is just information we like clients to know. A lot of times it's working directly with the financial advisor to either get the qualified charitable distribution go directly to the charity, or it might be to liquidate things so that you can make the charitable donation. Okay, let's go to case number 3, which is the Abbott family. So the Abbott family has Grace Abbott. She's widowed. She doesn't have any children. She came into our office, and here we have a little bit bigger picture of what her assets are. We know she has real estate, which is actually a family farm that's been in her family for years. It has about $700,000 worth of value in that. We have a retirement account of about $900,000. We have a brokerage account that's over $1 million. We have some stocks and bonds that she has, about $89,000, and then we have a bank account that she has $250,000. So know that, again, we're partnering with the financial advisor. So what our office does is we really want to focus on the legal issues here. So her total estate is a little over $3 million. Her concerns were this: number one, she's very actively involved in her church, and she wanted to make sure that a large portion of her gross estate is that entire $3 million. She wanted to make sure that 60% of her gross estate, and that includes probate and non-probate assets. That's what gross estate means. You can do, a percentage of probate assets. You can do a percentage of non-probate. Probate assets would be anything that goes through the will. Non-probate assets would be anything that can go through a beneficiary designation. So when I'm looking at the list of her assets, the real estate, the stocks and bonds, and the bank account, to the extent that the brokerage account we can do transfer on death and pay on death, the real estate, the stocks and bonds, and the bank account, those assets are considered probate assets. And the retirement account, the brokerage account, because we can do transfer on death and pay on death, they're considered, and along with the bank accounts, they're considered the probate assets. Anything with a beneficiary is non-probate. Sorry, I'm getting messages about sharing the screen. So give me a holler if you guys can't see it. Okay, so thanks, Jess. Jess is on it. So we wanted at 60% of that gross amount, meaning both probate and non-probate assets. We wanted to minimize her inheritance tax to the extent that we could. And what I mean by minimizing inheritance tax is that some assets are subject to inheritance tax and some assets are subject to inheritance tax and income tax. So when we're talking about minimizing her tax, we want to make sure that whatever is going to individual beneficiaries, to the extent we can, is only going to be subject to inheritance tax and not also income tax, okay? We want to make sure the farm gets to her nephew, and we want the residue of her estate to go to her siblings. So what we did for Grace is, let's advance the slide. The first thing we did is we calculated what 60% of her gross estate is. So if her total estate is a little over $3 million, then her 60% that she wants to go to her church is $1,804,554. Okay. Then my thought was retirement. So when we looked at her retirement assets, she has over $900,000 in a retirement account. Know that retirement is subject to inheritance tax and income tax as the beneficiary draw it down. So when I'm kind of thinking through in my head, the retirement is the asset that if we can get that to charity, that's where we want it to go to the church first. And the reason is because all of the other assets are only subject to inheritance tax. So if we can get all of the other assets to the individual beneficiaries, her siblings, her nephew, if we can get it there, then we've saved them some tax money. And part of her goal was to minimize tax. So when I met with a financial advisor, I said, you know what we need to do? We need to designate her church as 100% designated beneficiary of her retirement. And the reason why is her retirement is $900,000, but we know we want 1.8 to go to charity. So it will wipe out her entire retirement account. Now, no, it's not going to the church until Grace passes away. Okay, so it's not like the charity is getting it. It's not like the charity is getting her RMDs or anything like that. Okay, but we're going to designate the charity as 100% designated beneficiary in the retirement account. Then in her will, we're going to have a specific bequest of the farm to her nephew. We're also going to have a percentage that also pays to her church towards the mission fund with an explanation that we don't know the specific percentage. We're just going to say the percentage that equals 60%, because no, her retirement account can go up and down. Hopefully she lives a long time. She's going to be drawing that down. So it's not going to be 60% of the will, the assets that pass through the will. It could be a lower amount, but it all depends on the amount from the retirement that's paying out. So we would say we want a percentage to go to the church, but how we calculate that is we're going to look at what amount is going to retirement and the shortfall in order for 60% to get to the church. That's what's going to be the specific bequest in the will. Now, in 2022, if we were going to do that and she passed away, know that what Grace's will would do is it would make up the shortfall. So there's a shortfall of $895,000 approximately. So we would need the percentage in the will to be 42.7%. But we don't want Grace to have to keep changing her will every year. So that's why we just say the percentage calculated on the amount that would get us to the 60%. And how we figured that out is Grace's remaining estate. We subtract off the retirement because that's all going to the charity. Her remaining estate is about $2 million. So about 42.7% of that $2 million or $895,000 would go to the charity. That would then accomplish 60% of her estate. The thing that I need to tell Grace is that she needs to review her beneficiary designations, meaning that I am contacting her financial advisor annually so that we can all meet and figure out, do we need to adjust the percentage? Right now it's fine because her retirement has $900,000 and she needs to get 1.8 to the charity. But if we're having a good period of time in the stock market and that amount would go up at all, then we want to make sure that we're reducing that retirement designation, the percentage that's going to the charity. So again, the reason that I feel really strongly about that, and it depends on the advisor. Sometimes the advisor is already recommending that, they're on top of it, but sometimes the advisor isn't thinking about the fact that there's inheritance tax and income tax on the retirement. And so if we can get the retirement to go to charity, then all of our individually named beneficiaries aren't getting hit with two taxes. They're just getting hit with one. The residue of Grace's estate pays to her siblings. And so everything else pays out. So, and also I want to mention that remember, she can do designations on that brokerage account, a TOD or pay on death, POD. So again, we're coordinating with that financial advisor to make sure that we're making all of that work. So this is a way we're not doing a charitable trust. We're not doing a qualified charitable distribution or a QCD. We're not doing a charitable donation while she's living. These are things that we're just incorporating in her estate plan because she wants to make sure charities receive a certain percentage of her estate. That percentage, if you're looking at how it applies to your own estate plan, that percentage could be much lower. It could be 10%, it could be 15%. It's whatever percent you want. This is just the strategy in which our office will look at different assets and say what makes the most sense tax-wise to get those funds to charity. So this is an example of that. So I was trying to combine, legal concepts, but also just how can we allocate assets? So a lot of these are not necessarily legal documents that you have to do. It's just knowing the concepts to be able to figure out how to apply them to your situation. All right, case number 4 is the Barber family. So this one, we had the most going on. So let's talk about their family. So we have John and Joyce. They're married with 2 grown children. And one of my favorite things, and this is based on a client situation, again, changed facts, changed names, but one of my favorite things that I've ever had the pleasure to do as an attorney is help families fund education. I think that in my life, education has meant so much. My dad was a big proponent of education. And so when John and Joyce came in, one of the things they talked about is that they had already been funding 529 plans for their grandchildren. And they wanted to make sure that their estate plan incorporated educational funding for the grandchildren. And I was just so honored to be a part of it because I just know how much generosity when it comes to education has impacted me personally. So it's so nice for parents, grandparents to be thinking towards that next generation. So we had some real estate. John and Joyce had some real estate. We had some retirement accounts. We had a joint brokerage account that had about 1.4 million in it. We had some 529 accounts. I know this combines all of them. In this case, there were 3 grandchildren. So there was a certain amount in each grandchild's 529 plan. And then they had some Roth. So their concern was they came in also with some charitable planning. They wanted to make sure that a certain percent, 10%, went to their church. So they were very charitably minded when it came to their church. They also wanted to provide for their grandchildren's education. They did have 529 plans already started. Interestingly, they didn't come in with this next goal, but I added it after talking to them. And so it was protecting us long-term care costs. And the reason why this was important in John and Joyce's case is, especially John, really could not stop talking about funding these grandchildren's education. When I say he was passionate about it, I would say that's an understatement. He was on fire with the fact that he wanted to make sure these grandkids had their education paid for. So one of the things that came up was that as they age, if any of them needed a nursing home, that could potentially jeopardize their grandchildren's funding, because what would happen is a nursing home could attach to those funds. So I had John, who was so passionate about it, and again, he could do all of this great work setting aside money, and what happens if he or Joyce needs long-term care, could wipe that out. And so I talked to them about that we talked about all the different ramifications, so it was something they didn't think of, but when we were talking through how important it was, it became apparent that we needed to protect these assets against long-term care costs. And then lastly, we wanted 10% to go to the church. So what did we do in this case? So what we did, these trusts, we used a trust. This trust is not a foreign concept if you've been watching our virtual seminars. This is what we call our protector trust. So it's a trust that protects against long-term care costs. There's a 5-year look-back period for any assets that are transferred to this trust. So John and Joyce, it was a great time for them to do it. The thought being that we set up this trust, we transfer assets into it. Just go back real quick to the assets. So what I want you to notice here is they have 1.4 million in a joint brokerage account. This is what's important, okay? Because sometimes we have clients that come in that have more in their retirement, but in John and Joyce's case, they had a lot more in a joint brokerage account. So what we're going to do is we're going to transfer that 1.4 into the trust, okay? Because it's available for either one of their care. So we're going to transfer the 1.4 into the trust. Qualified funds cannot be transferred into these type of trusts without triggering the tax all at once. So know that we typically don't transfer retirement accounts, 401ks, any of those into this type of trust. We may develop a plan where clients are drawing it down slowly out of a 401k or an IRA and transferring it into the trust because we don't want to trigger that tax all at once. But John and Joyce were in a unique situation where a big bulk of their assets were in a brokerage account. So we put this into our protector trust. The protector trust is an irrevocable trust. Like I said, there's a 5-year look back period. The important part of this trust is what's highlighted. So what we did is we said upon the second spouse's death, to the extent not satisfied through the last will and testament, the trustee shall fund a grandchild's 529 plan who's still completing his or her academic career. And the trustee is going to calculate that by using the average annual cost of room, board, and tuition at the time of the second spouse's death for a grandchild who's not finished their academic career. That annual figure is then going to be multiplied by the number of years left in that child's higher education career or in what is anticipated. And this is why it's important. They have a grandchild who's only 11. So they have no idea. She's talking about being a pharmacist right now. So, we ran the numbers and said, well, she could need up to 8 years worth of school. So what we did here is we said, what's anticipated or expected up to 8 years. And then we talked about how, well, if she decides not to do that, the remaining amount in the 529 plan can be assigned to other grandchildren, other great-grandchildren. So know that that money is not lost. The other thing we talked about to John and Joyce is that if nobody, once all the grandkids get through school, if nobody in the next generation goes on for more school, you can cash out a 529 plan. There is a penalty to do that. But these grandkids, this is free money to them. It's not their money. It's, their grandparents' money. So we talked about how if we do have excess funds and worst case scenario, we don't have anybody else who would potentially ever want higher education, then we can always cash it out. Okay. But what we wanted to do is John really kept saying, I don't want there to not be enough money for these kids' education. So we also noted that we already know we have a 529 plan that they've started. So we're going to take this annual calculation, multiply it by up to 8 years or whatever we anticipate or is expected, and then we're going to deduct what's already in their 529 plan. So this trust is only funding the shortfall of that. Okay, so that way we're not overfunding. The other thing is if a child has finished their higher education, John and Joan have already been paid during their lives for that. So that's already accounted for. So we're not going to pay any more to that child. And then we do have just the way in which the 529 plans are allocated if and when that child would finish and there'd be money left over in the 529 plan. So this is how we handled it for John and Joyce. Now, no, they came in saying we want 529 plans. We want to have 10% go to our church. And I was the one who said, well, we might want to do these trusts. Now, know that John and Joyce could have said, you know what, we don't want to do the trust. That's not something we're interested in. I just wanted to show you a situation in which it's really helpful for the client to have protected that joint brokerage account. And then anything else goes equally to their kids, Justina and Jason, 50% pays outright. Let's advance, Jess. The other component of their plan was that 10% they wanted to go to the church. So 10% to church, which based on their estate, when we total everything up, their total estate was 2.7 million. So if they wanted 10% to go to the church, that's 276,000 based on 2022 totals. So we would actually designate the charity as an 89% beneficiary of their retirement. The reason is because their retirement is 310,000. So they have more retirement than the amount that goes to charity. So we don't want to put 100% like we did in the example prior. We only want it to be 89%, and it's going to be a contingent beneficiary because we want it to have this occur when the second spouse dies. We want to review it annually because the financial advisor may need to tweak this, but know that John and Joyce aren't going to have to update their trust or their estate plan based on the values because we don't have to put in their will, a different percentage based on the values. We don't have to do it to the trust. So that's the beauty of having it to retirement. So not only is this helpful because retirement is taxed twice. So again, we're getting the amount that we want to go to charity with an asset that's taxed twice, but we're also giving the client a way to change their estate plan without having to incur additional legal fees, meaning that it's just a change of beneficiary forms. They change the percentage with a financial advisor. Although we may be involved in the conversation, we're not drafting anything, so it saves them some legal fees. So we wanted to make sure it was a flexible plan that they wouldn't have to necessarily make changes to their document. Next month, so January 12th, Over the lunchtime hour, 12 to 1, we're doing a seminar called The Tangled Web We Weave, Social Security. I know everyone loves that topic. So we're going to try to the best we can to break it down so that maybe it's a little bit more understandable. You can register by emailing Amy, calling our office, or you can also do it on our website as well. And like I said, we always tape them and then put them up on our YouTube channel. So to the extent you can attend, you can always email Amy. She can send you the direct link to the YouTube video so that you have it. All right, Jess, let's go ahead and stop sharing our screen. I'm going to close this out and then I'd be happy to take some questions. So thank you so much for being on today's seminar. I always appreciate everybody jumping on over the lunchtime hour. I'm Samantha with the law offices of Samantha Wolfe. Please tune in next month for our next virtual seminar, and we'll look forward to sharing some more information.